I thank you.
My lords, on behalf of the respondents, I wish to confirm that our appearances are as before. I further wish to inform the Honorable Court and you, my lords, that in as far as the cross-examination of Dr. Gachagua'S is concerned, in the interests of time, we have nominated Dr. Mutomi Diokondo and Mr. Mokele to deal with that aspect of the matter.
My Lord, my name is Faith Waigwa. The necessity of why we need to examine in chief Dr. Gachagua'S is for the sole reason that we've had responses filed by Dr. Kindiki, Professor Kindiki, who is an interested party in the matter. We've had responses filed by the Senate, who are respondents in the matter. And my Lord, there are issues that need to be clarified by Dr. Gachagua'S in examination in chief. Thank you, my Lord. Thank you, my Lord. Perhaps we could either swear Dr. Gachagua'S in or affirm him. Yeah.
We want some clarification. My Lord, good morning. We were also served with the replying affidavit to the doctor's affidavit, one by Mr. Kindiki and the clerk of the Senate. And also being petitioners in these proceedings, Your Lordship, I'm seeking your guidance, Your Lordship, as to the participation of other petitioners insofar as the affidavit by Mr. Kindiki and Mr. Nyengenye is in issue. Otherwise, our quorum is as before.
My Lord, I don't understand the basis for the direction being sought from you, because you already gave the direction when we were before you that any party who desires to cross-examine the witness now on the dock would do two things. First, they would file a reply to that affidavit. And number two, in that reply, they would intimate whether they wished to cross-examine the witness now on the dock. Mr. Ndego Njiru cannot now purport to be ignorant of those directions, having not done what you directed should be done by anyone desiring to cross-examine this witness. Then he can't come here and just tell you we seek direction on what other petitioners should do.
thank you for that. The direction which Mr. Raymond has sought. I think directions which were we gave last time are very clear. For you to found a basis for explanation, you must have responded one way or another. So if you have filed an affidavit, I'll allow you to participate. If you have not filed, unfortunately, you cannot go back.
I'm well getting money.
Thank you, my lord. We may proceed. Please state your full name, profession, and your professional qualifications.
My name is Dr. Rigathi. I'm a medical doctor. Qualified from the University of Nairobi in 1975. I hold a master's degree in internal medicine from the same university. I'm a fellow of the American College of Cardiology. This Daktari is a giving evidence report. So we want to hear what they're saying and the court.
Speak loudly, Dr. Likonyo, so that their lordships can hear you easily. Pues sí. Que the court. Okay, the court assistant can adjust the microphone.
With the permission of the court, perhaps you could place something under the microphone to just lift it up.
Is that better?
Yes.
Your Honor, again, my name is Dr. Gachagua'S. I am a medical doctor, a graduate of the University of Nairobi in 1975, 20 years last August. Postgraduate internal medicine, the same university, 1980. Thereafter, fellow of cardiology, and now a member of the fellow of the American College of Cardiologists, trained in Minneapolis, the Mayo Clinic in the U.S. at 1985. Now practicing at the current hospital, previously a lecturer at the University of Nairobi.
Thank you. You have a document titled Affidavit, sworn on 28th April 2026, consisting of 12 numbered paragraphs. Do you recognize this document? Whose affidavit is it?
Your Honor, is mine.
Whose deponent's signature is on page 3 of 5 of that affidavit?
That's Your Honor, mine.
Do you wish to adopt the contents therein as your evidence in this matter?
Your Honor, I do.
Please tell the court whether you are acquainted with any party before these proceedings in a professional capacity.
I believe by the party means the respondent. Yes, I'm acquainted with my patient, Honorable Rigathi.
Okay.
Whom I have taken care of. From my records, Your Honor, my hospital records that I do have with me, I have been a doctor to the same Honorable Rigathi since, if I could, 5:10 p.m. on the 10th of July 2006.
Okay. When and under what circumstances did you meet the first petitioner, if at all, during the period in issue and relevant to these proceedings?
I believe for the purpose of this issue, we are referring to his hospitalization, the current hospital, which again, from my record, Paddington notes, happened at 3:25 p.m. on the 17th of October 2024.
And what happened when you met him? What happened next?
Your Honor, the reason for his coming to hospital, the court said he's on the way with chest pain, and we received him and acted accordingly.
From your experience and expertise as a cardiologist, what significance do such symptoms have?
Your Honor, you know, chest pain has two categorizations. There's chest pain that can occur if you have a heart attack, medical term called a cardiac infarction. That, when we say you have chest pain in that category, we look at the possibilities of that being real. That's what we call the risk factors. Here's a man, his age.
My Lord, with a very kind permission. With a very kind permission. I have listened to where the evidence, my Lord, is headed, and in my very humble view, we appear to be expanding the scope of the petition and the affidavit that is before you, Lordship. My Lord, it is important that we stick to what is in the affidavit. For purposes of that is why we're here today. If we attempt to then expand beyond what we agree, then we'll be prejudiced. We'll have to file further affidavits, etc., to be able to respond to the questions that are being raised. We must, I submit, stick to the
My Lord, if I may respond, I would refer the court to paragraph 5 of the affidavit. Basically, the questions are formulated based on what the witness deponed to. Unless they specifically state exactly what is new, my Lord, we request that you do allow the witness to proceed with his testimony.
Laying a basis does not presume introducing new issues by way of evidence issue. It doesn't mean you then introduce new technical issues that we need to deal with. We'll have to respond to.
I think the way forward is Ms. Waigwa, you will refer the witness to particular paragraphs of the evidence.
Okay. You do have the affidavit with you?
I do have it, Your Honor.
Okay. Please clarify what you meant under paragraph 5 of your affidavit.
Your Honor, paragraph 5 asks, based on my professional expertise, what do these symptoms mean? That the Lord is my answer to that is that based on my experience, those type of symptoms, depending on the probability of the disease, it depends on the risk factors. It would imply that you could be having a heart attack. That is my simple answer.
And based on paragraph 6 of your affidavit, what role or steps did you take with respect to the first petitioner having been presented before you?
Your Honor, if a man of that age and risk factors presents, there are standard protocols that we follow in medicine to evaluate that person. In this particular person, my mother named, there was additional risk factors of stress. And stress has brought its own problems of affecting the heart in a condition that we call a purposeful disease.
I refer you to paragraph 7 of your affidavit. Please clarify what you meant in that affidavit on paragraph 7.
I didn't know in medical practice, it is established that can be confirmed from present the chest in the hospital and have mental disturbance, you are then hospitalized for evaluation to see the extent, the dangers at which you present.
What examinations did you conduct, if any?
Again, Your Honor, after apart from the physical examination, taking a proper history of the circumstances, then you proceed with specific tests to include what we call a tracing of the heartbeat for factor response or an ECG, an ultrasound of the heart for this purpose of the layman's term, an image of the heart, and blood tests to check for any heart matter damage. Again, the honor is all specific.
Madam, very kindly, as my Lord did direct, could we be pointed to specific parts of both the affidavit and the attachments? By seeking clarification, we are then proceeding or extending beyond what is contained in this document. It then leaves us in a very precarious position.
I think that the doctor is here to give us expert evidence, and we must give him the room to give that evidence.
Yes. Can we clarify, my Lord, beyond that contained?
Yes.
Yes, can we clarify, my Lord, beyond that contained in the affidavit?
My Lord, if I may assist the court, the issue being raised is we have a written affidavit, which is sworn testimony. Ordinarily, that would be the evidence in chief. The second issue is that it is trite that where a thing has been reduced to a document, in this case, the affidavit, and the annexures thereto, you cannot, under the guise of examination in chief, purport to add to subtract from, to contradict, or vary. Even if this witness were to spend 2 days here, offering these things now being called clarification, it's just a waste of your time. Section 99(1) of the Evidence Act says that evidence is inadmissible.
I've been submitted to make a very brief reply. The rule of objections, as I know them, is that you object to something, objection irrelevant, objection something. There's no specific objection. You're being told that the objections, without a proper basis, we kindly request you to order that the examination in chief proceeds and concludes very shortly. Then my learned friends would have their time to impeach and to do anything lawfully the witness understands. Thank you, my Lord.
And so when we proceed with the latitude that those paragraphs in the affidavit gives you, and I think we must understand that we have an expert witness. It's also why we call him an expert. He has come to tell us something we may not know. Therefore, with that latitude, please proceed.
Thank you, my Lord. So, what you are referring to was in paragraph 6 of the affidavit?
Your Honor, exactly. That's the question. The things I've mentioned are in that affidavit. The ECG, for the Gachagua'S, the call, and the blood test. I've not gone outside that context.
Thank you. Please refer to paragraph 4 of your affidavit and annexure marked DKG 3. Annexure marked DKG 3.
Your Honor, is that point number 8?
Paragraph 4. Paragraph 4 of the affidavit.
Yes.
Paragraph 4, which talks on of the affidavit, which talks on when you approximately met the first petitioner, DKG.
Your Honor, as I mentioned earlier, that was
To clarified just now from my handwritten note of the hospital notes, which was on the 17th of October 2024 at 3:05 p.m.
No, my lord, now the witness is confirming why you are hearing objections. The witness is referring to his handwritten notes, which are not attached to the affidavit.
My apologies, Your Honor. I will not refer them again.
Okay, please refer to paragraph 4 of your affidavit.
Yes.
And annexure DKG 3.
Yes. Yeah.
That annexure is titled Discharge Summary.
I think you should have somebody to assist the doctor.
Yes.
So that we know exactly what point we are on at.
Yes.
Please not be this one there.
And there are timings mentioned in paragraph 4 of your affidavit.
Yep.
And there are timings indicated in the discharge summary. Could you explain those timings?
This date. And the date of admission, the date of discharge, will that be the issue? Your Honor, this is the day of discharge. The day of admission is the time that the patient was admitted to hospital. As I mentioned earlier, it's written here as 4:18 p.m. I would qualify that, Your Honor, that we must understand what admission date and time.
No, my lord, that's exactly what the law says the witness can't do.
Yes, that one can't do.
I can't explain.
You can
No, Your Honor,
what you should try to avoid is any interpretation of the document outside the document.
No problem. Admission time 4:18 p.m., 17th October 2024. Discharge 20th November 2024, 1:36 p.m.
Okay, under paragraph 4, there is a timing of 3 p.m. What transpired at that time?
3 p.m. is the time of admission that the patient arrived in the hospital and was duly attended to.
Just a clarification. 3 p.m. and there is the 4:18.
That's what I was going to, and I was stopped from saying, Your Honor.
Please clarify those.
If I'm allowed.
What happened at 3 p.m.? What happened at 4:18?
Exactly, Your Honor. That's the
My
point.
lord, we still retain the objection. It is in black and white in the Evidence Act. If it is in the document, no amount of oral evidence from this witness can be admitted for purposes of adding, subtracting from, clarifying, or all these things is now purporting to.
Your Honor.
Let me rephrase that, Your Honor, and because the times you've read them out, when did you see the patient? What time did you see the patient?
3:25.
As per paragraph 4 of your affidavit.
Yeah.
What time did you see the patient?
Approximately 3 p.m.
Okay. What time was the patient admitted to hospital?
At that time that I talked about.
Which was?
3 p.m. But on the paper here, and you must allow me to clarify, because you have to understand why that date is there, or that time is there. That's why we are here, to explain to you the discrepancy between 3 and 4. Your Honor, if you allow me, I have an answer to that.
Just answer what she asked you, what the counsel asked you.
Yeah. Answer. Proceed.
The discrepancy is because as one comes to hospital, that is not admission. Admission is when the technical details are entered in the admission papers.
Be taken care of. Who is your insurance? Who is paying? And then the account department will put that time after admission time.
Okay, thank you very much.
If there's no cover for that, you will not be admitted. You will be seen.
Thank you. Thank you, Dr. Now refer to paragraph 8. Paragraph 8 of your affidavit and the annexure again marked DKG3, which is the discharge.
On the task printed today, on the affidavit, you say you were discharged on the 20th of October 2024.
Okay.
On this other case, says discharge is 20 November. There's no error in that. If Your Honor allows me, I can explain why that is so.
Please explain.
The answer is again, discharge process in hospitals involve accounting. You must pay before you are discharged. And even if you have been discharged by the doctor and you've been gone home and you're not paying your bill, you are technically not discharged. We call it an open bill. It's the when you come and clear all your bills and everything else, that you are technically financially discharged.
Thank you. Refer to DKG3, the annexure, which is a discharge summary, at page 4 of 4. Who wrote the discharge summary? Who wrote the discharge summary? It's at page 4 of 4.
Your Honor, if you allow me, I have to define what we mean by writing and discharge summary. Because our hospital, current hospital, is a training institution. We have medical interns, we have medical registrars, we have junior consultants, we have senior consultants. And the typing of the discharge summary, printing on the computer is done. We have medical interns, we have medical registrars, we have junior consultants, we have senior consultants. And the typing of the discharge summary, printing on the computer is done by either the medical officer or the registrar or the intern. In this one, it was done by Dr. Sarita. But the consultant overreads what has been seen there and signs that is correct. So it was prepared by Sarita, signed by me, Dr. Gachagua'S.
Okay, thank you very much. Still on page 4 of 4 of DKG3 annexure, which is the discharge summary. What did you mean by the follow-up, that ongoing review, follow-up?
I believe in medical terms, what we mean by follow-up when you are discharged from hospital is that although you have been treated, there are issues that need to be followed up. How are you faring? You actually, at the current hospital, actually call patients at home and ask them, you were discharged last week, madam, how are you faring? But in more than that, we give you an appointment to come back, just to make sure what we did was correct and you are feeling better, and if anything needs to be done, and then most of the time, you actually need almost a lifetime follow-up.
Okay. Is annexure marked DKG3 to your affidavit true and accurate copy of the original discharge summary?
Your Honor, it is.
I'll go to the last bit. During the period the first petitioner was under your care, what communication, if any, did you receive regarding his condition from anywhere?
Well, Your Honor, there are always follow-up calls from relatives, parents, and friends. And in this particular case, Your Honor, I must be honest enough to specify that I did receive a call from our president asking about the status of the patient, and responded accordingly.
What did you communicate in response to that inquiry?
Well, the first time, Your Honor, I just said that we are in the process of doing various tests, and as soon as we have a conclusion, we shall let it known.
Okay.
But if Your Honor, you must allow me to say this, that when I said that, I had to seek clearance from the patient that was okay so to do, which he gave me permission.
Okay, very well. On my second last question, please refer to paragraph 10 of your affidavit. Paragraph 10 of your affidavit. And annexure DKG4.
Yes, Your Honor.
And tell this honorable court the relevance, if any, of the annexures in relation to your testimony.
You know, Your Honor, during this
hospitalization. This hospitalization for reasons that happened that time became a public issue, and there were public notices in newspapers and television services covering the issue.
Okay. Lastly, please refer to paragraph 11 of your affidavit, and in summary, what you'd like this Honorable Court to understand regarding the first petitioner's admission and treatment.
Your Honor, I have only one statement to make, and that the Honorable Rigathi Gachagua was admitted to hospital on the date so specified and discharged on the date so specified and treated according to the standard of medical practices.
Thank you very much. That is all, my Lord.
Thank you.
Good morning, Dr.
Good morning, sir.
My name is Mudhomi. I think we know each other.
Lovely. Nice
Yes.
to meet you in these circumstances.
I will ask you a few questions.
My name is David Kimani. I'm the CEO and founder of Apollo Children's Science Park.
Yes. After the events described in it, correct or incorrect? It's correct. Was this affidavit placed before the Senate?
I think we are aware because we exist and this request has come now.
The request has come now. You don't believe, sir, it is bizarre that a request of this nature in a case of this nature will be made 1.5 years down the line? Would you agree with me? That's bizarre. It's not natural.
Sir, I don't know the proceedings.
Okay. Fair enough. This affidavit has attached some medical records, Exhibit 3. Correct or incorrect?
Correct.
That exhibit, was it placed before the Senate?
I would be aware, sir.
You are not aware. But you will confirm whichever date we take from the multiple dates on it. These are again events that this document was available about 1.5 years ago. By the date given years down the line, would you agree with me? That's bizarre. It's not natural.
Sir, yes, that's...
You have to agree this document was available.
Yes.
You also have to agree that with due diligence, this document would have been placed before this honorable court about 1.5 years ago. True or untrue?
No opinion, sir. I don't know.
No opinion. Fair enough.
Yes.
You have now attempted to explain a discrepancy between paragraph 3 of paragraph 4 of your affidavit. It talks of 3 p.m.
That's correct.
But Exhibit 3 at the top right talks of 4:18 p.m.
About an hour difference, yes, sir.
You agree that's a discrepancy on its face? On its face, without more looking at it, is there or is there no discrepancy?
None whatsoever, sir.
Are you saying 4:18 p.m. is the same time as 3 p.m.?
There are different times for different...
There are different times. Therefore, you agree with me, sir.
But could the witness be given the opportunity to complete answers to his questions without being cut short?
Dr. Gikonyo, is it your testimony that the time 3 p.m. given at paragraph 4 of your affidavit is the same time given as 4:18 p.m. in the medical record.
They are different
Good.
occurrences.
They are different times.
Occurrences. They are not the same thing we are describing.
Okay. This explanation you are now offering on the witness doc, is it given anywhere in your affidavit? The explanation for the discrepancy, is it set out anywhere in your affidavit?
It should be understood.
No, the question is it set out anywhere in your affidavit? That explanation you are now offering in court.
Not there because
it is not there.
It was never raised. I would have given an answer if it was raised.
We are here to raise it, unfortunately.
And we are given an answer.
Let's stick to that page 104. Dr. Gikonyo, you have to agree with me that we identify individuals in Kenya by reference to their national identity card or passport number, correct or incorrect?
Depends on the purpose, sir. In my class, they call me DK.
Does this document indicate the identity card of the patient being attended to? Does it indicate the identity card number? National identity card number. Either it does or it does not.
We have the client's ID number in
That's
his record.
not my question, sir. My question is, on its face, does this document disclose the national identity card of the patient it describes?
Deliberately not.
Good. Does it indicate the travel passport number of the patient?
Deliberately not.
Good. Deliberately not.
Yes.
Very good answer. Does it give the patient's name?
Deliberately not.
Therefore, you have to agree with me, sir. A document that does not contain the patient's name, does not contain the patient's national identity card number, does not indicate the passport number. We have no way, based on the document, of ascertaining who is the patient described in that document.
We do have. We can ask the person who prepared it.
No, the person on the doc is you. Does this document on its face, sir, disclose the identity of the patient described there?
Only by initials, RG.
RG?
Yes.
Which could mean anything, isn't it?
To other people, but not to me.
Okay. Fair enough. I put it to you, sir, that you having brought this document to court, you cannot run away from the fact that it doesn't disclose the identity of your patient.
Deliberately so when it was prepared. But now I can disclose. If you ask me who it is, I'll tell you. RG
could as well be Rob Gitao, right?
Could be, but it is not.
It could be Ruth Gitanga.
It is not. Ask me what it is.
To you, sir, it can be anyone and anything.
In this category, no.
Okay, fair enough.
You can ask me who is RG. I tell you who is RG.
The problem is we don't believe you. That's why these questions are being asked.
You ask me, why did you write RG? I explain.
It is me who chooses, unfortunately, the questions to ask. So, let's go to that. The title of the document is a medical summary.
Correct.
You have to agree there is a difference between the summary and the primary document.
That is true.
So has the primary document been placed before this court?
I don't know.
Can you see it anywhere in your affidavit? You can take time to flip through.
Not on my affidavit.
It is not in your affidavit. You have to agree with me, therefore, in the absence of the primary document, an independent reader has no way of confirming whether this summary agrees with the primary document.
They can ask the writer who is in front of us here.
No, on the documents, we are dealing with the document. In the absence of the primary documents, would the third party have a way of confirming whether the summary is accurate?
If that document was adequate in itself, I would not be here. I am here to answer questions pertaining to the document, to say whether it's correct. If it was adequate in itself, you wouldn't call me here.
We actually called you, Dr. Ikonyo, because the document has just too many gaps.
For me
Let's go to the paragraph of your affidavit that talks of the 48 hours to 72 hours.
Correct.
That's paragraph 7 of your affidavit.
Correct, sir.
If that were true, it would mean this patient, and we mean patient RG, whose identity we don't know,
which I can confirm.
It would mean that this patient would have been discharged on or before 20th October 2024. Correct or incorrect?
Or a month later?
We are following the documents, sir. Your paragraph says he was admitted for how long? 48 to 72? Your paragraph 7.
Sir, please read correctly. Recommended.
And when does it say he was discharged?
On the 20th.
Of which month?
Of October.
Of October, good. And what is the discharge date given in the medical summary?
November.
November. That's actually 34 days later.
Correct.
Correct?
Yes.
You have now attempted in your exam in chief to explain the discrepancy.
Not attempting, I did explain.
Okay. Let's take it you have explained. You have explained while on the witness dock.
Yes, Your Honor.
The discrepancy of 34 days, right?
Yes, Your Honor.
Is that explanation set out anywhere in your affidavit? The explanation you gave this court for that discrepancy?
Yes, this is understood. I have
No,
explained.
my question is the explanation you are now offering 1.5 years later, is it said, show me the paragraph of your affidavit that explains the discrepancy?
It was not required.
It was not required. But for the record, is it given in your affidavit, that explanation?
Not given because not
Good.
required.
It's not given. This summary gives the consultants who are attending to the patient. Can you see that part of Exhibit 3?
I do, yes.
It begins with yourself. Who are the other doctors?
Your Honor, if you allow me to explain.
You can look at it.
I know it.
I haven't asked the question for you to explain. You can only answer questions I ask.
I know the names on the list. I can look
The
at
names
them,
given there.
Yes, I can look at them, but I know them.
You know them.
All of them, yes.
Is the maker of this document one of the doctors who are indicated as attending to this patient?
No.
No.
Do you need an explanation
So
for
we
that?
don't have the primary document, and we have a summary made by a person who did not attend to the patient.
Not correct.
Not correct. Is Dr. Sarita, just for the record, indicated as one of the doctors in this summary who are attending to this patient?
She is not a consultant.
My question is she indicated as one of the doctors who are attending to the patient? From the list given at the top, is Dr. Sarita one of them?
Your Honor, I must explain what this list of consultants mean to the audience here.
We are not interested in that. The question is she indicated? Either she is, and Dr. will add quickly if you answer the question. The more we kick about the bush, unfortunately, the longer time it will take.
But I can't allow you, sir, to proceed on a misunderstanding.
My Lord, the witness has no...
Excuse me, Dr.
Yes.
You came here to give evidence.
Yes,
you
Your Honor.
answered questions as put to you by counsel.
Okay.
Without any
But Your Honor, if you
deviation. Just answer the questions as put to you. If you don't know, you say you don't know. Then we proceed.
And that's how the law works, Dr. Gikonyo, just for the record.
Thank you. I understand now.
So is Dr. Sarita indicated in this document?
Should you find that there's a need for clarification,
yes,
they will ask you to clarify.
All right.
Yes.
Go on.
So, Dr. Gikonyo, is Dr. Sarita, the maker of this summary, indicated as one of the physicians that were attending to the patient, known as RG? On the face of it, is she indicated in the list of those doctors?
Not as a consultant.
Is she indicated in any other way?
As a preparing, as the one who prepared the document, yes.
That's not my question. Just wait. Is she indicated as attending to the patient in any medical capacity? The maker of this document.
The people taking care of the patient are not listed.
I thought they are listed here, sir, about 6 of them.
Those are the consultants. There are other doctors in the system, medical officers, intensive care doctors, and other people. And as I mentioned earlier, we are a teaching hospital.
Is there any material you have placed in your affidavit to show those other doctors and the fact that they were attending to the patient?
No.
Good. In fact, on the document before the court, we have no way of knowing who else other than the 6 given that attended to the patient.
Only by asking the person on the doc.
No, we are talking on the document, sir.
Not on the document, sir.
Good. Let's go to the bottom of that document. Bottom left. That document has a computer timestamp at the bottom left, correct? Bottom left, below prepared by Dr. Sarita.
That is right. 2011, 24, 1240?
12:40 p.m.
Yeah.
So what is the date and time of this document's preparation as per that timestamp? It is prepared on the 20th of November 2024 at 12:40 p.m. Correct or incorrect?
Right, that's correct.
Now let's go to the opposite side of the page, bottom right.
Yeah.
What is the date and time given? The date you confirm?
20 November 24, 12:35, 19.
12:35. You have to agree those are 2 different timestamps. Correct or incorrect?
That's correct.
You must agree, sir, that it is not possible for this document to have been prepared at 2 different times as it purports to say.
I won't understand why the computer would do that. I would have to check on the computer data.
Unfortunately, sir, you have to agree with me that on the face of it, this is a discrepancy as to the time when this document was prepared. It has 2 timelines. Which one do we take?
I do not know.
Good. You don't know.
I won't add that it would matter.
You have testified that this patient, at the prior history, we go to page 204.
Yes, Your Honor.
And you have summarized it there.
Yes, Your Honor.
Have you placed before this court any primary documents to prove this alleged prior past medical history?
If required, is available.
No, my question, sir. Have you placed before court any material to show that this patient had prior history of the conditions described there?
None at all, but if
None at all.
If
Good.
required, Your Honor, it's
None at
available.
all.
It's available. I have it on me here today.
Unfortunately, it's you who testified on affidavit on oath, sir, that he has passed history. So you have to agree with me then, in the absence of that material on the record. This is just an allegation. We have no way, based on your affidavit, to confirm that the patient described there had this prior history.
You have no way, but if you are interested in knowing, it can be provided.
Doctor, you say you did a number of tests on this patient.
Yes, Your Honor.
Including an echocardiogram.
Yes, Your Honor.
2D. One is called 12 LED and the other one 2D, right?
Yeah.
You must agree with me that that machine for echocardiogram generates a report and a graph. Correct or incorrect?
Of course. Yes, it does.
Yes, it does. Have you in this affidavit attached that graph that the machine generates to show that the patient has the conditions described in the summary?
No, it's not. Available if required.
No. My question is, have you attached to the affidavit the report that the echocardiogram machine generates?
Definitely not.
Good. Have you attached the report that the other machine automatically generates?
Not attached, but exists.
Fine. Have you attached the images that were supposedly taken of this patient?
If I thought they would be useful for this court, I would have attached them. I thought it was not necessary to attach them, but they are available if required.
But you would agree with me that the images and the graphs and the reports would be the primary document evidencing the illness, correct or incorrect?
Correct.
Therefore, if that is correct, you must agree with me that this summary, in the absence of those images and those graphs and those reports, cannot be the evidence that patient RG had the conditions described in your affidavit.
Unfortunately, I would not agree with you.
Fair enough. You say he also took some blood tests.
Yes, Your Honor.
Have you attached the laboratory report of those blood tests to this affidavit?
If you are required, we can.
No, Doctor, my question is...
They are not attached.
Have you attached
Deliberately
the
not.
laboratory report of the alleged blood tests?
Deliberately not. Available if required.
So again, based on your affidavit, you have to agree. We have no way of knowing whether there were blood tests or what were the results of any such blood tests.
I disagree. We have a way of knowing. You can ask me, I can produce them.
Page 3 or 4 talks of hemoglobin, platelets, and blood chemistry and other things. Correct or incorrect? Either it does or it doesn't, Dr. Ari.
It does.
Do we have in your affidavit the primary document, that is the laboratory report for all these tests?
Available if required.
No, my question is, do we have it in your affidavit?
Definitely not. They are not there.
Definitely not.
Yes.
In page 404, there is some information there about follow-ups. Have you produced before this court any document on that follow-up?
Has not been requested.
The question is, Have you annexed it, sir?
No.
You have not annexed it. So again, I put it to you. There is no material before this court to confirm there was any follow-up. Dr. Gikonyo, in summary, you have admitted you have no material before court to show the prior history of the patient. You have confirmed there is no material before the court to evidence his medical condition when you supposedly attended to him. And there is also now no material of the follow-up. Is it not because this gentleman was in your hospital to hide away from the Senate? He was not sick. I put it to you.
Let me laugh a little bit first.
Trust me, I too have been laughing about it.
Sir, Your Honor, I must apologize. I must apologize. I must apologize, Your Honor, for that. I must apologize, Your Honor. But honestly, sir, if the question arises as to those documents that have been raised, if they are available, and if you are looking for justice and honesty, you can ask me to provide them. And it takes 2 seconds. They are here.
Yes, you may have them, but they are not on the record, sir.
You can have them.
Unfortunately, the law does not permit you, Dr. at this belated stage, to even refer to them, because they should have been put on the affidavit. But to my summing up questions, your affidavit alludes to some media coverage,
yes, Your Honor,
of this alleged illness.
Yes, Your Honor.
Did you give yourself a press conference on this illness?
Yes, Your Honor, on demand from the press.
On demand from the press?
Yes.
Dr. Gikonyo, is it standard medical practice for doctors to give press conferences as to their patient's illness?
It depends on the sensitivity of the issue.
The question, sir, is it standard medical practice for doctors
yes, when it's
to
required.
call press conferences?
No, sir, we don't call for press conferences.
Okay.
Press comes to us.
When you were giving this press conference, the case before the Senate was proceeding, correct or incorrect?
Most likely so.
You found time to give a press conference, but you didn't find time to go and tell the Senate?
Oh, no.
Okay.
In what capacity would I go to the Senate?
Good. Wouldn't the Senate, where the proceedings were going on, sir, have been the natural forum for you or any of your colleagues to go and tell Senate that the witness cannot come because he's been admitted in hospital?
I'm not sure if access to the Senate is available to every common person like me.
That's all from me. I'll yield the floor to Mr. Mukele Melod to wrap up the cross-exam.
Well, there is a serious allegation in the form of a question raised by Dr. Thionkulu that Dr. Gikonyo was hiding the first petition. That was posed, and I'm not sure that Dr. Gikonyo was given the opportunity to respond.
Why don't you respond in your response?
Just for the record, the witness answered and he said his answer was to laugh.
We'll deal with it.
To deal with it.
We'll deal with it, yes. Thank you.
Senior Counsel Dr. Gachagua'S has covered quite a bit of ground. I will only have about 3 or 4 questions for this witness. I don't think I have much to add. Good morning, Dr.
Good morning, sir.
My name is Edwin Mukele. I represent the 3rd and 4th respondents. I've been permitted by Senior Counsel, Professor Ojeda, to ask 1 or 2 questions on behalf of the Senate.
Thank you, sir.
Now, I had your last comment to be that you are not sure, and this goes to Dr. Kiankolo's very last statement, you're not sure whether you have access to the Senate. That's what I heard you say.
Yes, I said so, sir.
Now, Dr. Gikonyo, the affidavit that you presented before court is sworn on the 28th of April 2026.
That's correct.
That's correct. Do you recall when the first petitioner was impeached?
Not the exact date, but I believe the same day that he came to hospital.
The same day that he came into hospital. Would that be the 17th of October 2024?
Most likely so, sir.
Most likely. This is about, we then receive your affidavit in court about 1.5 years.
That is correct.
After he has been impeached.
That's correct.
Now, going back to your evidence, and I'll be very brief, my lord. When asked a question on whether the documents you presented would have been presented to the Senate, your answer was, the request has come now. That is what I had you to answer to one of Dr. Kiankolo's questions.
Yes, that's why I'm here today.
The request has come now.
That's why I'm here today, sir.
So the request, Dr. Gikonyo, to file the affidavit and the attached documents has come now. That is what you said, yes?
Yes, I mean, yes.
From whom did you receive the request?
From the petitioner.
You received the request from the petition?
Yes.
Do you recall, do you know, when the petitioner first filed the petition? Might you know?
No, I don't. And I'm not interested.
You're giving evidence and you're not interested in the context of a petition in which you have no interest. Is that what you're telling the court?
Yes, that I'm here purely on a medical issue, not on a court issue.
That is startling, Dr. Ari, I must say. It means, in my view, you probably don't understand the reason you're here. But I will go on. You have also, and this is my last question, mine, very brief. You have also confirmed that you do not know whether the affidavit and the documents attached were before the Senate. Do you have any information on that?
Not at all.
You don't have any information on that?
And I agree with you, sometimes I really don't know why I'm here. Because my understanding is I'm here to answer medical questions about the petitioner in hospital.
So,
about law things and court and Senate, so I am ignorant.
So, Dr. Gikonyo. Dr. Gikonyo.
Yes, Your Honor.
You cannot tell the court, from what I understood, whether the affidavit and the documents presented today, sorry, the affidavit sworn by yourself on the 28th of April, were before the Senate at the time of the impeachment proceedings.
I wouldn't know. And
you wouldn't know.
Your
That's
Honor,
okay.
I have no interest in those matters.
That's okay. That's okay. We understand that you do not know why you're here. My Lord, those have been my very brief questions on behalf of the Senate. I beg to.
Thank you.
Thank you.
Dr. Gikonyo?
My Lord, we had Dr. Kamoto to us just 2 questions, then the witness can be re-examined. If you permit him, please.
My Lord, there was no affidavit filed by Dr. Kamoto, and you have given directions before the commencement of this process.
Let Dr. Kamoto speak for himself. Dr. Kamoto, did you file any affidavit?
Yes, my lords, my lady.
Did you file any affidavit?
We have put our responses. We are doing a joint approach to this matter. We have a joint approach to this matter, and that's why you find, my lord, that not every one of us makes submissions or presentations on every occasion.
I think while you could be correct, if I allow you, then there's no basis why I did not allow the other side, because they could also just hang on that point. I think for clarity or purpose, I don't think it's fair to allow you to proceed.
Very well. We are most obliged.
My Lord, I'll proceed with the re-examination of Dr. Gikonyo. Very quickly, Dr. Gikonyo, I'll refer you to paragraph 11 of your affidavit.
Yes, Your Honor.
On the reason why you filed the affidavit. Could you come clear or clarify why you saw this affidavit, referring to paragraph 11?
Your Honor, that is the way I understood it, until I was made to understand that I had to understand other things of the Senate and other court matters. Because as far as I'm concerned, Your Honor, that paragraph summarizes why that I make this affidavit in my capacity as a medical expert, not a legal expert, in adult cardiology, to assist this honorable court in establishing that the first petitioner was duly admitted to hospital on the date in question, underwent treatment. That was my understanding.
And you had earlier confirmed that the contents of your affidavit were true?
Completely.
To the best of your knowledge?
Completely. And I took an oath on that.
Just to clarify a few issues that have propped up during cross-examination, and I will go back to paragraph 4 of your affidavit, and I'll be direct this time round because it cropped up. Is there any admission issues in paragraph 4?
None at all.
Thank you. So at 3 p.m. on 17th of October 2024, what exactly happened?
At around 3 p.m. is the word. Approximately is the word.
Yes.
If you want to know the exact time, it was 3:25. I have it.
What happened?
At around that time is when the petitioner arrived in hospital.
Thank you.
We took him in. We started the normal thing that we do for history taking his weight, blood pressure, and such. At that time, if you allow me to explain, is the time we start now the admission process.
Thank you.
And admission is a process, not an instant. And as we are doing those things, the accountants asking who is going to pay for this, blah, blah. And when they are ready, then they fix on the computer, this man is now admitted.
So when was he admitted?
According to our document here, 4:18 p.m. That is when the actual documentation of admissions were completed. These are technical details of timing and writing. Before that time, we are still seeing the client. We are doing the necessary things, but he's technically not admitted because the accountants have not allowed us to do that.
Thank you. I'll refer you to page 1 of 4 of the discharge summary. And on the top, the patient name is Mr. RG. Who is RG?
You know, Your Honor, if you come to hospital and you are an ordinary citizen, we put your full names and all your other names. There are clients we don't put names on record.
My Lord, we still object. That evidence is extrinsic to the record. It is inadmissible. And my good colleague here knows that question is also impermissible.
The question was actually raised in cross-examination, and what we are seeking is a clarification on who RG is.
And Your Honor, I have said, our practice in a hospital to protect privacy, because these documents go around hospitals. The malaria parasite is positive, blah, blah, it's for the one. So we use codes.
Can you just
who is
ask him who RG is?
RG is the Honorable Rigathi Gachagua.
Okay, is there any other identification information in that document? Have a look. Is there any other identification information with respect to that, without necessarily reading it out?
There's a mobile telephone number also.
Thank you. Would you confirm whether there is any discrepancy between the affidavit and DKG3, the discharge summary?
Not at all.
Thank you. And lastly, is DKRG, what document is DKRG? Because there's been an allegation of a medical report. What is DKRG?
It's a discharge summary.
It's a discharge summary.
It's not a medical report. A medical report gives details that may not necessarily be required by this court. But if required, Your Honor, it's available.
And in your discharge summary, you were confirming what you deponed to in paragraph 11 on the purpose of the affidavit.
Absolutely, Your Honor.
Which is admission, discharge, and treatment.
Absolutely.
Thank you, Your Honor. That's all.
Just one very brief question, Dr. Gikonyo. It was put to you by Dr. Kionkulu that you admitted the petitioner, His Excellency Rigathi Gachagua, to hide him, suggesting he wasn't sick. And I think you responded by laughing. Now that you have finished laughing, will you please answer the question? Was Rigathi Gachagua sick or not sick? Why are you hiding him? Or not sick? Why are you hiding him in your hospital? Please answer. It is a serious question.
I must say I laughed because I thought it was not a serious question, because maybe it is not common sense. But however, the answer is yes, he was sick. We admitted him. We have data that's available to any medical person. We have medical reports. We have traces of his ECG, his echoes, everything, lab data that's available and available on demand by this court.
And apart from the documents, Dr. Gikonyo, you are here as a doctor, head doctor who was treating him.
Your Honor, that's why you called me, to answer those questions. That I've answered to the affirmative. I was the one who was treating him with my team. He was sick. We have data. We have provided an affidavit. If there's any further questions, we will provide it.
That's all, my lords. Your leadership.
Thank you, Dr. for coming to clarify those issues. You may now take your seat.
My lord, can Dr. Gikonyo be released as a witness?
I would say that he can take his seat.
Okay.
He can be here or he can go home.
Oh, okay. that is the only clarification. I don't think he'll be going home. He'll be going back to current service.
And there's something down there.
And there's water. There's water. There's water. Is that your water?
Yeah.
Yes, my lords and my ladies. Again, we are now in the proper business of the submissions, and I am ready to proceed, subject to any other direction that you may want to.
What is the kind of directions that you will be seeking in relation to procedure?
My lord, if it works for the court, we would want to have the remaining part of the day for us as the respondents try and push and possibly conclude our submissions.
we also hope that if time allows, we could then have any responses so that the matter is closed today. But I think what we will be asking for specifically is about, we will not go beyond 8 hours on the outer side.
We're talking about 8 hours and we're talking about concluding today.
Well, you have previously sat up for about 10 p.m., but I wanted to get your direction so that we also know how to budget and plan as to when we'll be ending, so that we know which testimonies you take and whether or not you want to have us progress with the submissions this morning.
So that we don't have to take written.
So, my Lord, we will, in the course of making our oral submissions, be also submitting on what has transpired during the cross-examination. So that need not bring any complication. The respondents will deal with the issues in the course of highlighting their written submissions.
So, my lady, on behalf of the National Assembly, we will have 4 of us making our submissions. We do not expect to go beyond 2 hours. That's for the National Assembly.
Yes, Your Lordship, my Lords, on behalf of Senate, I will lead the team and will be on point. We'll be assisted by 2 other counsel on other questions. Not more than 2 hours. I think I should take not more than 2.5 hours. I'm normally very brief.
My Lord, on behalf of Professor Kidure Kindiki, we also need 2 hours. We'll be sharing the time with the team that I lead.
On behalf of the Attorney General, I wish to confirm that we do not wish to make any further submissions, as we believe that...
I would be requesting that within 30 minutes, I can formally, before they start, because it is a matter they would have a right to respond to summarize what are the issues and brief reasons why that decision should be incorporated and the sense in which it should be understood by this court as part of the petitioner's submissions. I believe in particular the first petitioner, whom Mr. Ochier said a lot of things about that issue of the Senate and the Special Committee, would have an interest in that particular matter. So may I request for directions on that issue. It is already filed, the decision is also filed, so that all that would be required would be to hear what would be the best way to proceed before the respondents have started. I believe, in view of the proceedings that have taken place, the petitioners have just closed their case for today. Only that my learned colleague, Professor Muigai, had made submissions on behalf of the client Attorney General. So that's all, my Lord.
My Lords, we became aware of this decision as soon as it was issued, and this is largely due to my younger learned friend who circulated it, and for which I thank him. It's a very weighted decision from the Constitutional Court of South Africa. It will be our submission. It is totally irrelevant. What I would propose we do, just like my learned friend Mr. Kibe Mungai has done, he has filed his own submissions on it. I would beseech my Lord to open the same path to anybody who wants to submit on it, and we leave it at that. We do not wish further time be expended on this is the court, this is the judgment of a foreign court about foreign law. So it should not detain us, and we should proceed as my Lord has suggested.
That's a sensible suggestion on our side. And you also think that the court can save time for rejoinder by allowing most of the petitioners to make their rejoinder in writing that way, and then the wish to conclude today could be achieved.
Mr. Kibe,
it's just that it is irresistible for the first petitioner not to join issues with Professor Gedu Muigai, that this decision is utterly irrelevant.
It is?
Think he said, he told this court that the decision is utterly irrelevant.
I thought you were confirming that.
My concern is that there cannot be a more relevant decision on the attempt to avoid a committee of parliament to do the investigation, and on the jurisdiction of the court to question actions and decisions and resolutions of parliament. This decision answers to those two issues, but if everybody gets leave of this court to put in written admissions on that point, then I'm in agreement with senior counsel, Professor Gedu Muigai. Thank you.
I knew, my lords, one day before we retire, my learned friend and I will agree on something.
Thank you very much. I think we have more or less agreed that we treat Mr. Kibe's submissions on that issue. We allow parties for submissions on that issue. And between now and then, and the time we retire to write our ruling, if you have an authority, just file it. Just file it, we'll consider it.
Thank you. Only that we shall say something about it during the rejoinder.
All right, that is okay.
Thank you.
Yes, IABC.
My Lord, we have Ms. Joy and Mr. Nora. I think the President in court.
We will particularly take note of time.
If Your Lordship could give me a second to catch my breath. It's a hassle to get from the back of the court to the front. It pleases my lords, my lady, My name is Noura Abdul Kadir. I appear alongside Ms. Joy, Ms. Faith Kiende, Mr. Derek Asala, and I also hold brief for Mr. Mahat Somani for the 16th respondent, the IEBC. My Lord, together with these oral submissions that I will make, the 16th respondent also relies on the submissions he filed on the 25th of October 2024, 27th of October 2024, and the replying affidavit sworn by the then CEO, Mr. Marjan Hussein Marjan, sworn on the 25th, my Lord, of October 2024. We will be relying on those documents, my Lords. We will briefly highlight on a single issue, my Lords and my Lady, and that issue is the IBC's involvement under Article 149 of the Constitution regarding vacancy of the office of the Deputy President. And the main question that we will be asking is whether the Constitution contemplates any role by the IEBC in the filling of that vacancy. My Lord, Article 49 identifies two actors expressly. That is the President and the National Assembly. Therefore, the question that arises for this court's determination is whether, beyond those two expressly identified individuals, those two expressly identified actors, does the Constitution intend any additional role for any other actor, but for purposes of these submissions, the IEBC? My Lord, it is our humble submission that that particular article is deliberately narrow and precise by design. It provides two constitutional actors and two constitutional functions. First, the President, who nominates a person within 14 days. Second, the National Assembly. So on a plain reading, my Lord, of that article, the Constitution does not introduce any third actor, any intermediary, institution, or any additional clearance mechanism where IBC would play any particular role. And my Lord, in answering this question, and because these submissions have been made severally before this honorable court, is what would have been or what could be the intentions of the drafters of the Constitution. And in asking ourselves this question, my Lord, we interrogated the harmonized draft and the Bomas draft 2004. Under Article 168 of the Bomas draft 2004, my Lord, the process was expressly confined to the President and Parliament. And while this process was a bit more complex than what we have in our present Constitution, involving both houses of Parliament, it still made no mention of the IEBC. When we move closer to the current Constitution that we have in the harmonized draft at Article 170, it is more similar to our Article 149. Again, there was absolutely no mention of any role played by the Electoral Commission at any point. Therefore, both drafts reveal that the drafters of the Constitution, sometimes we belabor too much on what the drafters intended. It could be easier to just reach out to Professor Gizmuga and ask him what he intended. But it is clear from those two drafts that there was no intention to involve the Electoral Commission. Therefore, we ask ourselves the question that where could the qualms and the quarrel by the petitioner have arisen against the IEBC? And that would fall on one article of the Constitution. That is Article 148, the qualifications of a deputy president. If you look at the qualifications of a deputy president under Article 148, the Constitution references you to the qualifications of a president in 137, which further references you to the qualifications of a member of parliament, which is Article 99. My Lord, it is our submission that the petitioners proceed from an assumption that the IEBC must therefore undertake a formal verification or clearance exercise as though the filling of a vacancy under Article 145 were an electoral process, which we humbly submit that it was not. My Lord, it is our humble submission that if there is any role that is not expressly stated or implied under Article 149, it would be to the two actors who have been mentioned in that article. That would be the President and the National Assembly. To satisfy themselves that the nominee meets the constitutional requirements of that office. My Lord, in that context, and seemingly out of abundance of caution, that we submit that the President sought factual information from the IEBC. And the IEBC merely responded with information that was within its custody, whether or not an individual is within the voter register. My Lord, we submit that up to that point, up to the point that the IEBC provided that information, it was not under any constitutional obligation or duty under Article 149. It simply provided information that it possessed. Now, my Lord, the other qualm that the petitioners seem to have is whether the information issued by the IEBC was improperly provided by a commission which was not properly constituted. My Lord, I humbly submit that this particular issue has been heavily argued before courts, and there is several case law that demonstrate the roles played by the IEBC, either by the Secretariat or the Commission, or the Secretariat and the Commission. And we humbly submit one of those very important authorities, which can be found in our digest, is the presidential petition of 2022, E005, Raila Amolo Odinga and others versus the IEBC. My Lord, we submit that in that case, three distinct roles came out clearly. That the IEBC possesses a role where the Constitution references, or where the legislation references the Commission. It could mean the Commission and the Secretariat, as was elaborated in that case, with the issue of verification and tallying. So a reference to the commission could mean the commission and the secretariat. The instruction is to the commission, but the action is to be taken out or to be handled by the secretariat. And that can be found on paragraph 46 of that decision. My Lord, the second role would be that if legislation or the constitution references the commission, it quite simply means the chairperson and the commissioners. And that role is reserved strictly for the chairperson and the commission. And the decision went on to note that there are such roles that can be taken or handled by the secretariat, such as this one I will submit. My Lord, from that precedent, two principles clearly emerge from this binding authority. Number one, the Commission acts institutionally, not through personal involvement of the commissioners, in every function. It doesn't act through the commissioners in every single function. And that the Secretariat performs the day-to-day administrative and technical functions. So, my Lord and my Lady, the act that is complained about involves no deliberate decision-making by the Commission. It would not require any decision-making by the Commission. It requires no policy formulation, no exercise of constitutional discretion. It was purely factual and database-driven, involving retrieval of information held in the voter register, verification of that information, that indeed the individual whom you sought information from is a registered voter, and communication of the same to the requesting party. I mean, IBC would do that of anyone. If you were today to request that information from the IBC, it would provide it easily. It did not have to have come from the president for the IBC to have acted and given the information. So that information could have come either way. My Lord and my Lady, I will point out three decisions that speak to the same. That is, I believe it is in our bundle of authorities, County Government of Uasin Gishu and two others versus the IBC, County Government of Kisii and two others versus the IBC, and County Government of Lamu and two others versus the IBC. Similar to this case, in all three cases, the position of Deputy Governor fell vacant for whatever reason. As is required by law, in all three cases, the Governor nominated an appointee to take up the position of Deputy Governor. The individual was vetted by their respective county assemblies. And during this period of time, the IBC did not have commissioners, three of whom having resigned, and the rest, three of whom having retired, their term having come to an end, and the rest having resigned. The respective county governments wrote to the IBC requesting that it gazettes these individuals. The CEO then, acting out of abundance of caution, felt that this was a role reserved for the Commission when it is properly constituted. And the courts, in specifically County Government of Kisii and two others versus the IBC, said that this is a merely administrative task arising from an already concluded legal process and is not dependent on the composition or quorum of the Commission. In County Government of Uasin Gishu and two others, the court said that it is an administrative function of communication and notification, and the Secretariat is capable of undertaking that role. The court, and I'm going to quote the court directly, does not call for a commission to sit, deliberate, and come up with a decision. Therefore, my lords and my lady, I humbly submit that if these simple tasks of communication, notifying, giving information were to be subjected to the commission, then the IEBC would lack purpose in a period where the commission was not properly constituted and that there were no commissioners. Therefore, my lords and my ladies, we humbly submit that on those two grounds, two grounds that had been raised by the petitioners, that petition and those allegations fail as against the IEBC. My lord, I'll take a minute just to make reference to the prayers that were sought against the IEBC, specifically in the amended petition, that is prayer K. My lord, the prayer itself takes issue with the fact that the IEBC provided the said information. My submissions have completely covered that the IEBC plays no role. There is no constitutional role under Article 149. The only issue that arises, or that I haven't covered in the prayer, is the overnight clearance that violated Article 10 of the Constitution. And I have to say apologetically, my lord, that this prayer is absurd. My lord, IEBC is being complained of for efficiency, that we delivered information requested in a timely manner. I mean, that is what is needed of government. I have never seen a petition that comes to court to complain about the efficiency of an institution. My lord, I submit that there was no clearance. We were simply giving information that was contained in the voter register. I humbly so submit. Thank you very much, my lords.
Thank you. Thank you very much.
Yes, my lords and my lady, on behalf of the National Assembly, our representation is led by myself. We have Mr. Paul Nyamodi, Mr. Alex Mbaya, Elias Ouma, and Mr. Crispus Kitala. My lords, to support our submissions this morning, we will rely on the affidavit of Samuel Jeroge, dated the 21st October 2024. We'll also rely on the second and seventh respondent submissions, dated the 17th of September 2027. We have, in addition to that, filed a list and bundle of authorities dated
17th September 2020.
2026, sorry. No, 2025. List and bundle of authorities dated the 17th of September 2025 as well. My lord and my lady, we fully adopt those written submissions. I will, my lords and my lady, start by making reference or drawing our attention back to submissions by learned learned Senior Counsel Professor Githu Muigai in relation to or on behalf of the Attorney General. I will borrow from his very able submissions on two critical aspects. Number one, on the nature of impeachment proceedings, and number two, on the jurisdiction of the court. In relation to the nature of the proceedings or the nature of impeachment proceedings, learned Senior Counsel Professor Githu Muigai describes those proceedings as proceedings sui generis and political. And it adds that this is not just in Kenya, but globally. He then fortifies that position with two critical decisions. One decision is the decision of the Supreme Court of the Philippines, where the court says that impeachments are a constitutional measure designed to protect the state from official delinquencies and that it is political in nature. Locally, Professor Gido Muigai did refer the court to the case of Kawira Mwangaza versus the County Assembly of Meru, affirming that impeachment are inherently political and distinct from judicial processes. My lords and my lady, that being the position taken by the respondents, I then would want to trace the architecture of impeachment proceedings within the context of our Constitution. And I start with this point, my lords and my lady. Every 5 years, the people of Kenya go to the ballot to elect their leaders. In particular, and of most interest, is usually the election of the president, together with his deputy. Then, additionally, the election of parliamentarians. My lords and my lady, these elections determine or define the executive leadership and governance of a country. Now, central to the question of elections is the issue about the sovereignty of the vote. That under Article 1, Sabbatical 1 of our Constitution, the sovereignty is in the hands of the people of Kenya. It is for the people of Kenya directly making a determination who then choose who their leaders in those respective elective offices would be. That election, ordinarily, for context, is by secret ballot. And the reason why I say that is so that we understand that in the exercise of sovereign will, there is no need, there is no requirement for any Kenyan expressing their will to give a reason why they make a decision in the manner in which they make that decision. That is what in constitutional parlance, my lords and my lady, has been referred to as the power of we the people. Now, what is the significance of that election? The significance of that election is that it forms the basis of a social contract between the people of Kenya and their democratically elected leaders. That determination of governance or election of leaders is not without terms and conditions. Under our Constitution, my lords and my lady, the Constitution spells out in very clear terms what the expectations of the people of Kenya in relation to their leadership should be. Specifically, I draw your attention to the provisions of Article 10 of our Constitution. My lords and my lady, Article 10 of our Constitution, for some reason, has gained prominence over the years since 2010, just on the narrow question of public participation. But I want to this morning, my lords and my lady, draw your attention to the fact that under Article 10, the subtitle is national values, and more importantly for the proceedings that we have before you, national values and principles of governance. Article 10 then spells out, 10.1 spells out how it applies and how it's supposed to be interpreted and applied. My interest is drawn specifically to Article 10, Sabbatical 2, which says the national values and principles of governance include, then there's A, B, C, and D. Now, those are not mere wishes. Those are the expressions of Kenyans saying that if you are to be a leader in Kenya, then you must lead on the basis of those values. I, for the sake of what is before us, draw our attention to sub-article 10.2c, which talks about good governance, integrity, transparency, and accountability. Why do I say that? Because impeachments are founded on the basis of good governance, founded on the basis of integrity, transparency, and accountability. Malonza Meledi, Kenyans, being fully cognizant of the high authority, high moral authority that they wanted from their leaders, did not stop there. They still, under Chapter 6 of our Constitution, went on to provide for 8 additional articles. The 8 additional articles, Malonza Meledi, speak to the leadership and integrity of the leaders. The specific title, Malonza Meledi, is Leadership and Integrity under Chapter 6. At Article 73 talks about responsibility of leadership. Of significance for purposes of our submissions today, I would want to draw your attention to 73.1, which says authority, responsibility, that is authority assigned to a state officer, is a public trust to be exercised in a manner that then the people of Kenya spell out what they expect of their leaders. Of interest to me is what appears at Sabbatical 1A, Roman 3 and 4. Roman 3 speaks of brings honor to the nation and dignity to the office. At Roman 4 it says promotes public confidence in the integrity of the office. Chapter 6 then goes on to provide for many other ways of dealing with leaders at different levels of leadership within the country. Now, again, under that very Chapter 6, Kenyans then make it a cardinal and mandatory requirement that for any public officer to assume office, they must take an oath of office. Now, that oath of office is the epitomization of a social contract that I was speaking to. That oath of office, Malonza Meledi, takes different forms depending on the office that one is supposed to be assuming. In the context of a president and deputy president, at Schedule 3, that is the third schedule, there is a very clear indication as to what that oath is supposed to be. It says, I, so and so, in full realization of the high calling, I underline high calling, I assume as the president or acting president or deputy president of the Republic of Kenya, do swear or solemnly affirm. The Constitution makes you to swear to the people of Kenya that I will be faithful and bear true allegiance to the Republic of Kenya. It also says that I will obey, preserve, protect, and defend its Constitution, this Constitution of Kenya, as by law established, and that all laws, together with all laws of the Republic, and that I will protect and uphold the sovereignty and integrity and dignity of the people of Kenya. I underline, protect and uphold the sovereignty, integrity, and dignity of the people of Kenya. A similar oath of allegiance is provided for by the deputy president. When you get time, Malonza Meledi, you'll take an opportunity to look at the nature of the oath. What is the significance of these oaths? Malonza Meledi, we submit that the oaths are a solemn commitment by the leaders to uphold the Constitution. It also creates public and moral binding commitment to uphold the sovereignty, integrity, and dignity of the people. And more importantly, that it is the accountability pledge in the social contract that I spoke to. At a later part of my conversation, or rather my submission this morning, I'll refer us to the consequences that the failure to adhere to these conditions or these terms of engagement would lead to in respect of leaders at one level or the other of government. Of interest, and just to show how significant the question of the integrity and this commitment to these articles, the provisions of Article 10 and Chapter 6 are, the President, upon assuming office under Article 132 of our Constitution, is given a duty which is akin to reporting on how they are performing. Under Article 132(1)(c), under the title Functions of a President, it says, once every year, report in an address to the nation on all the measures taken and the progress achieved in the realization of national values referred to in Article 10. It means a responsibility is put on the president or on the president to then report on the measures they've taken in the realization of Article 10. That just tells you how significant how important that provision is to the people of Kenya. Now, that defines to a large extent how the executive arm of our government works. The people of Kenya then do not stop at that. They say that in order that we hold you accountable, we must then have an arm of government that deals with or that keeps you on check, that exercises oversight over these elected leaders. Now, it is important to then make reference to Article 1, Subarticle 2, that the people of Kenya can make these sovereign decisions either directly or through their democratically elected leaders. So that then the source of authority for parliamentarians, for instance, is as a result of being the democratically elected leaders. And I'll speak to why that is important. I draw your attentions, my lords and my lady, to Article 93 of our Constitution. Article 93 of our Constitution establishes our parliament. That our parliament consists of the National Assembly and Senate. Now, at Article 94, the people of Kenya go on to determine what the role of parliament is. My lords and my lady, I am sure we'll have an opportunity to read the entirety of Article 94. But for purposes of a presentation that we are making before you at the submission, I draw your attention to the provisions of Article 94, Subarticle 2. It says, the Parliament manifests the diversity of the nation, comma, manifests the diversity of the nation. It means that is where every single section or, if you wish, person or member of any class in Kenya is represented in Parliament. It takes into account the minority. It takes into account each and every community in Kenya. It goes on to say, manifests the diversity of the nation, says, represents the will of the people. Read this in the context of Article 1, Subarticle 2, that Parliament represents the will of the people. That when parliamentarians speak, they do not speak as parliamentarians. They speak representing the will of the people. And more importantly, under that 94.2, and exercises their sovereignty. Again, read in the context of Article 1, Subarticle 2, it gives those people, the parliamentarians, the power to exercise the sovereignty of Kenyans. Now, this is a complete surrender in the constitutional sense, that Kenyans surrender their rights to their democratically elected leaders to be able to make decisions on their behalf. And from a craftsmanship point of view, one would want to argue that once we have elected our leaders, we cannot, every time we think there's an infraction of any aspect of a constitution, we then call Kenyans into a plebiscite. That is why we have leaders who then, in the event that there's such an issue, can speak for the people of Kenya. Now, I then draw your attention to the provisions of 94.4, that which says that Parliament shall protect this Constitution and promote the democratic governance of the Republic. Again, promote the democratic governance of the Republic. The Constitution then, under that Chapter 8, goes on in a slightly more granular sense at Article 95 to say, that is the role of National Assembly, to say the National Assembly represents the people of the constituencies and special interests in the National Assembly. In particular, I would draw your attention to 95 Subarticle 5, which says the National Assembly reviews the conduct in office of the President, the Deputy President, and other state officers, and initiates the process of removing them from office. My lords and my lady, that article does not give us any option. It says the representatives will review the conduct of our elected leaders. Separation of powers. If they find that any of the conducts does not fit within the confines of Article 10 and Chapter 6, then the instructions from the people of Kenya is very clear. Initiate the process of removing them from the office. Role of Senate at Article 96. I refer, my lords, to Article 96, Sub-Article 4, that the Senate participates in the oversight of state officers by considering and determining any resolution to remove the president or deputy president from office in accordance with this, with Article 145. My lords and my lady, why is this important? It is important because we see a textual commitment, and this was a submission made by Learned Senior Counsel Githu Muigai. There's a textual commitment of this oversight responsibility to the parliamentary arm of government, that is the legislative arm of government. We then are drawn to, maybe just so that I conclude that, an explanation under Article 96. Now, this oversight is exercised in differently in different jurisdictions. In Kenya, the Constitution at Article 145 and Article 150 dictates that it is through impeachment. In other places, it is through a vote of no confidence. Both those processes, as submitted by Learned Senior Counsel and with the support of authorities, are political processes. That's why it is important for us that we appreciate the defining four corners of an impeachment proceeding and the role then subsequently of the court. I also add that the manner in which this legislative arm of government exercises its authority is by, number one, deliberating, as we saw in the proceedings before the National Assembly, as well as in the proceedings before Senate. They deliberate, they interrogate, they question. After they've taken an informed position, my lords and my lady, they vote. That is how parliamentarians make their determinations. Now, that is how they express the will of Kenya. That is how they express the sovereignty of the people of Kenya. It then follows that a test that is to be applied in determining whether that exercise of that will and sovereignty was done properly can only be a political test, and I explain why. If we, for instance, conflate that test to be a test in the judicial sense, then the Article 10 and the values that it ascribes then immediately run into challenge. Because when we say, for instance, good morals, how will the court determine good morals other than by being subjective? There's no standard through which the court would say this is a good moral, this is a bad moral. That is why the people of Kenya say our elected leaders will determine that for us based on those specific provisions of the law. I want to give this in the context of Article 145, Fred Mutatis Article 150. Look at the grounds of impeachment, for instance, under Article 145. One of the grounds is that the existence of, or rather serious reasons to believe that the president or the deputy president, as the case may be, has committed an offense. Now, from a political perspective, the test is purely a prima facie test. I'll be looking at, having listened to what has been presented, what do I make of it? Having heard what has been said, what do I make of this judgment from a morality perspective? If that same question was to be presented to the court, then there are defined standards. For instance, in relation to issues criminal, it is beyond any reasonable doubt. So it means those two tests, if we were to conflate them, then we will be judging a political process through what I would otherwise call a wrong lens. And that is, again, to be supported by the decisions in by the Supreme Court of Philippines, as well as the decisions in our own cases of the Court of Appeal in Martin Nyaga Wambora and three others versus the Speaker of the National Assembly, where the court says that courts have neither jurisdiction to initiate a motion, consider a resolution, nor hear charges against impeached officer. The province of the court is solely to decide on the rights of the individuals, not to inquire how Parliament performs its discretionary duties. I dare add when a vote is presented to you, my lords, there is no requirement that a parliamentarian or a member of the National Assembly voting one way or the other assigns a reason as to why they voted how they voted. That vote is assumed for all intents and purposes to be the expression of the people who elected that person to that National Assembly or to the Senate, as the case may be. That is the same position taken by the Supreme Court in the Sonko case, which is part of the decisions that we've cited in our bundle and list of authorities. The court then says, courts should be slow to interfere with the exercise of parliamentary discretion, and the mandate of the courts is restricted by the doctrine of a separation of powers to deciding on individual rights and fundamental freedoms. In other words, the processes that were undertaken by the legislative arm of government. Now, I want to draw inference just to make this point sink. Let's look at the provisions of Article 144, for instance, where the president could be removed from office for incapacity. Now, the process goes on. At the tail end of it, Article 144, subarticle 8, yes, Article 144, subarticle 8, the ultimate test is that the report of the tribunal shall be final and not subject to appeal, and if the tribunal reports that the president is capable of performing the functions of office, the Speaker of the National Assembly shall so announce in the National Assembly. Now, what is important to draw here is that the people of Kenya are deliberate about saying these processes should be shielded from the court process. And that is the political component of these processes. And why is that important? We come from a history, my lords and my lady, where issues touching on the presidency have taken more than 5 years. In fact, we've had to go to subsequent elections when those matters were still pending in courts. Yet they are matters that are purely political in nature. My lords, for those reasons, the people of Kenya are very deliberate. It's not an omission. They're deliberate that they would want to omit the court from that political process. Now, having outlined that constitutional architecture, we then draw our minds to how did we, or how did the National Assembly conduct the impeachment process that is the subject of this trial and these proceedings this morning. My lords, my lady, this is to be found in the affidavit of Samuel Njoroge, specifically paragraphs 9 to 28. Now, at the test or the consideration that the court will be looking at is the manner in which the National Assembly complied with the provisions of Article 150, read with Article 145, mutatis mutandis. Now, number one, there's the question of establishment of the grounds. The grounds are under Article 145.1. I need not read them. What is important, though, is that once a member of Parliament presents a motion in the nature of Article 145, that is for impeachment of a president or a deputy president, as the case may be, then the Speaker of the National Assembly would have to satisfy himself on a number of threshold questions. I'll refer you to where this was done. Now, the first item that the Speaker looks at is whether, as framed, the grounds that have been presented in Parliament meet the grounds in Article 145. That is, I think, to be found in the Standing Orders number 64.1, which defines how that motion is supposed to be made. It says in a very granular sense that it is supposed to be in writing, and number two, it must spell out the grounds that are articulated in Article 145. Standing Order number 64.1A then goes into looking at the manner in which the Speaker reviews those grounds as to whether they fit within the constitutional architecture. And that is a role that is under those specific standing orders left for the Speaker of the National Assembly. My lords and my lady, I'll draw you and I'll probably point you in the course of my submission to the findings of how the Speaker of the National Assembly deals with those requirements. But the sum of it is that the Speaker of the National Assembly satisfies himself at page 745. Let me just try and get the page 745. As to the two tests, both under Standing Order number 64-1 and Standing Order number 64-1A, that both those conditions have been met. Now we go to the second test, and I'll take you just in a short moment to the Hansard to speak to this. We go to the second test, which is the threshold test. Now, the motion must be supported by at least, in the words of the Constitution, if a motion under clause, a member of the National Assembly supported by at least a third of all the members. So the first threshold test is that the motion is supported by at least a third of all the members. I'll draw your attention to how the Speaker of the National Assembly deals with that, determining that question. He makes an express finding that all the members refers to all the members elected, and if he gives a specific number as to what all the members mean. He then gives a mathematical representation that for that threshold to be met, there must be at least 117 members supporting the motion that is presented. In the case at hand, my lords and my lady, the number of people who supported the motion was 282. 291, members of the National Assembly supported the motion presented by the member for Kibwezi. Now, the second test is under Article 145(2), which says, if a motion under Clause 1 is supported by at least 2/3 of all the members of the National Assembly, now the second threshold test under Article 145 Subarticle 2 is 2/3 of all the members of the National Assembly. Again, the Speaker of the National Assembly, at the conclusion of that exercise, makes a finding as to the number of people who supported or voted in support of the motion. In particular, they say 291 out of 349 members voted in support of the motion. That is what learned Senior Counsel Professor Githu Muigai referred to as a super majority. My lords, in terms of compliance, those three thresholds are fundamental. I want to take a quick moment to just draw your attention to the specific area where this is to be found in the communication from the chair. Yes, I'm there, my lord and my lady. The Hansard runs from page 744 in volume 2 of the annexure SN3 of the affidavit of Samuel Njoroge. My lords and my lady, after identifying the specific issues of concern, the Speaker at page 748 says, having examined the notice of a special motion by the member for Kibwezi West, I find the special motion meets the requirements relating to the form and threshold set out in Articles 145(1) and 151(b) of the Constitution and Standing Order 64. Then goes on to say, I have also satisfied myself that the number of members who have appended their signatures in support of a special motion exceed the minimum threshold of 117 members. Then further on it says, having determined that the special motion is admissible, let me now focus on the next step of giving notice to the special motion to the House. The Understanding Order number 47-4A, which provides that with respect to the motion of removal from office, a member shall give notice of a motion in the House within 3 sitting days following the approval by the Speaker. Now, that my lords and my lady, when you get an opportunity, is how the Speaker of the National Assembly deals with the threshold questions. We submit on behalf of the National Assembly that those thresholds were met. After meeting the thresholds, what then do we address our minds to? We stop there, my lords and my lady, to ask ourselves a number of questions that arose in the course of a presentation before you. Learned Senior Counsel Paul Mwite, supported by Counsel Mr. Kibe Mwingai, Mr. Ndegwa Nziru, and even Mr. Ogada, described the pace at which the impeachment process was done as a breakneck speed. My lords and my lady, where does the pace, or what determines the timelines within which impeachment is supposed to be done? A reading of the entire Article 145 gives a total of 19 days within which the impeachment process should have been completed. And my lords and my lady, that said, if you calculate the 2 days, the 7 days, and whatnot, it gives you a total of 19 days. That said, my lords and my lady, the question of the timely and expeditious determination of an impeachment motion is a dictate of the Constitution. It is not a whimsical escapade or undertaking by the either National Assembly or the Senate. Those timelines are cast on stone, and they must be done within those timelines. Now, it is not unique when we're dealing with issues touching on the presidency because of the sensitivity of a presidency to a republic. Under Article 145 of 140 of our constitutions, any question as to the validity of election of a president is determined within 21 days. Again, under Article 144, a motion for removal of a president for incapacity is to be determined within 30 days. What do we read from these very tight timelines? We read the history that we've walked, that in dealing with these matters, which are obviously possibly divisive and also very contentious, if you leave parties to attend to those processes as they would, we would not be able to make those determinations within the contemplated timelines. My lords and my lady, that is the nature of our Constitution. Learned Senior Counsel Paul Mwite then also submits that impeachment is a nuclear option and should be the last resort in dealing with disciplinary issues around a presidency. I mean, dealing with impeachment of a president or his deputy. My lords and my lady, contrary to that, Article 10 and Chapter 6, couched in very mandatory terms, speak to what I'd call the political hygiene of a country. They determine what follows. And remember, in the course of my presentation, I said I'll revert back to Chapter 6. At Article 75, my lords, 75(5) says, no, 75(3), sorry. A person who has been dismissed or otherwise removed from the office for contravention of the provisions specified in Clause 2 is disqualified from holding any other office. That is an important dictate of the Constitution. It doesn't give us an option. It means in black and white that to the extent that His Excellency the Deputy President was found to have been in breach of this Chapter 6, specifically the ones referred to Clause 2, which is to be read with Article 10 and Article 73. Once he is impeached, the Constitution says he is disqualified from holding any office. I underline any office. It is not just about the presidency, it is about any public office. And I think that answers the question that learned Senior Counsel quote. An office either at the national level, at the county level, at the constituency level, and I dare add, even at the county assembly level, any office that is defined under Article 260 of our Constitution, the test being a simple one, will that office require that the payment to that office holder be made from the consolidated fund? So the long and short of it, my lords and my lady, is that this article is a bar, unless changed through any other process, is a bar to His Excellency the Deputy President from holding any office, any public office. I go to the next question around fair hearing. This was submitted to quite at length by my learned and good friend, Mr. Dudley Ochiel. I want to add that from a factual perspective, and this is available in the Hansard, each of the senators, each of the members of the National Assembly was presented with the volumes or the documents that contained the petition, the first respondent, His Excellency Rigathi Gachagua, then the Deputy President, was given an opportunity to respond, which, again, as you'll see from our Hansard, he very ably responded to in writing. He was again given an opportunity to attend in person before the National Assembly and before the Senate. Again, he seized that opportunity and attended. He did not just attend alone, he attended with a battery of at least 14 lawyers. That is what the law contemplates. Now, the lawyers were given an opportunity to ask questions, and the Hansard will bear me witness. I'll refer you to the specific aspects of the Hansard. That the lawyers representing the Deputy President then had very robust engagement, questioning each and every of the grounds that was represented or that was tendered for purposes of the impeachment. After that, the members of the Senate, just like in the National Assembly, were given an opportunity to ask questions. Why is that important? It is important because it shows that these two houses were given an opportunity to interrogate. And interrogation here is so that they're able to make informed decisions. My learned colleague Moses will address us at a later stage on the question of public participation. You will see how that public participation played in. The only point I would want to make is that when that public participation was conducted, it was conducted so that the members of the National Assembly and Senate alike could touch base with the people they represent to see what their thoughts were in relation to the question of impeachment. It is not for this court, I add. It is for the members of the National Assembly and the Senate, as the case may be. Now, is that a case of somebody who was not afforded an opportunity to be had? My lords and my lady, that brings me to the central question in relation to that issue. The central question is in relation to the adjournment that was declined by the Senate. Let me say this. I will refer you to the provisions, or rather to the recordings in the Hansard, on how the application for adjournment was made by learned senior counsel Paul Muite. My lords and my lady, it is apparent from those proceedings that no ground or no evidence was presented before Senate to enable them, to support the exercise of discretion. With the material that was available before Senate, they made a determination on the basis of the fact, and they did ask this, that the proceedings before the House were time-bound proceedings. They put a specific question to learned senior counsel Paul Muite. What do you want us to do? My lords and my lady, I refer you to the specific answer that was given by learned counsel Paul Muite. Now, not a single piece of paper was presented to the Senate for them to be able to make a determination as to the allegation of ailment. Why is that important? It is important for this reason. The petitioners have come before you to try and question the exercise of discretion of the Senate in denying the motion or the application for adjournment. It is very clear that whilst in Senate, they did not tender any material to support that application. I underline any material. Learned Senior Counsel, the Honorable James Orengo, and this is captured in the Hansard, speaking to this same process, says at the very least he would have expected at least a doctor from Karen Hospital to come and confirm to the Senate the condition of His Excellency the Deputy President then. That did not happen. That, my lords and my lady, we are seeing an affidavit emerging from the woodworks today. Of what probative value? If you're being invited, my lords and my lady, to evaluate the material that was before the Senate at the point at which they were making that determination declining the adjournment, what is the value of an affidavit being filed before you today to support that application? My lords and my lady, it must be abundantly clear that that application is not being made before this court. This court is merely being invited to review the manner in which Senate exercised its discretion. I dare add that absent any supportive material, then Senate had absolutely no basis of granting the orders that were sought. My lords, it should not be lost that even in Senate, and this is also evident in the Hansard, the petitioner, His Excellency the Deputy President, then Rigathi Gachagua, was represented by a team of 14 lawyers. That is on record. My lords and my lady, are we saying that out of these 14 lawyers, none of them would have imagined that it is important to lay a document to satisfy the Senate or to give grounds for the adjournment that they were seeking? We think that is a far cry. That was a deliberate omission. This court cannot now go into looking for reasons that ought to have been looked at, or items or material that ought to have been looked at by the Senate, but which were never quite placed before the Senate. It means that the affidavit that has been presented by Dr. Dan Gikonyo before the proceedings, to support the proceedings before you, is of absolutely no value, because no material can be introduced. And I would equate it to the court proceedings. My lords and my lady, if I was to make an application before you today, my team leader, learned Professor Githu Muigai, is not in, and I just say, I want us to adjourn these proceedings, important as they are, then I tell you, I suspect that is unwell. Chances are the court will say no. If the court says, I have not established the grounds for grant of that adjournment, would it be open for me to now go to the Court of Appeal to say that I now have a document 1.5 years after the application has been made? I want you to look at this affidavit. It confirms indeed that the person in issue was actually unwell. That material, having been missing in the proceedings before Senate, cannot be used as a basis of making a determination on that on the exercise of that discretion one way or the other. My lords and my lady, I would want to very quickly, I'd said I'll refer the court to various areas within the Hansard that speak to these items. In the third and fourth respondents' annexures, marked as Part 4, this big volume, unfortunately it's not paginated, they are the proceedings of the Senate, specifically at page 7, where Learned Counsel Paul Muite makes the application for adjournment, and it runs all through to page 15. My lords and my lady, I ask that when you get an opportunity, just read for yourselves and you see the deliberations as they unfolded before the Senate. There's then the communication by the chair of the Senate, which appears at page 15 after that of the same document. Again, the reasoning of the Speaker in relation to the question of adjournment, ultimately putting the matter for resolution by the whole House. My Lord, that is the part of this Hansard which speaks to how the application for adjournment was made. I need not read the whole of it in the interest of time. I'm sure the court will find an opportunity to read that. I think I'd referred the court to the specific parts of the Hansard from page 744 of volume 2, annexures running from page 711 to page 1301, specifically page 744 running through page 746 up to page 749. My lords and my lady, that is how the National Assembly deals with the issue of the issue of threshold. Yes, my lords and my lady. So we then ask on behalf of the National Assembly that you find that the petitioners have not met the threshold for you to exercise the review that they're inviting you to exercise. I want to add, as I mentioned earlier, that the review that is supposed to be before you is a review of a determination arising out of a vote. Is it the sort of review that is contemplated in these proceedings? I say, or I add one point to that, that because the members of the National Assembly, the members of Senate, are not required under Article 1, Subarticle 2, to give the reasons as to why they voted however they voted, what would be this reason that would be testing if we were to apply a test, for instance, of Wensbury unreasonableness under the anisminic sense? There'll be no reason that we'll be looking at. From a political sense, my lords and my lady, the only solution left is by the people then saying that that specific member of the National Assembly did not express our will. We will deal with them in two ways. The Constitution says either you deal with them at the point of re-election or you deal with them through a recall, not in the manner in which we seek to want to, in a granular sense, lay blame on the findings of the members of Senate. I pray that the petitions be dismissed. May I now cede the ground to my learned friend, Mr. Mushemi, to make his presentation. I'm most obliged.
Thank you, my lords and my lady. My name is Michael Mushemi. I appear for the 9th respondent. Your lordships, we are relying on our replying affidavit dated the 22nd of October 2025. Our submissions dated 15th February 2026. Our supplementary submissions and list of authorities dated 5th of May 2026, and our further list of authorities dated the 12th of May 2026. Very briefly, my lords, since the enactment of the 2010 Constitution 16 years ago,
Parliament has only met the threshold of 2/3 majority on any bill or any motion on 2 occasions. The first of these occasions was during the passing of the BBI bill, the now defunct bill, where on the 7th of May 2021, the National Assembly approved that bill with 224 members in support and 63 voting against. And in the Senate, on the 11th of May 2021, with the bill being passed by 51 members, 11 voting against and 1 abstention. My lords and my lady, my client, the 9th respondent, brought this motion pursuant to Article 145(3) and in historic numbers, first as required by the Constitution to garner 117 signatures, he was able to garner 290 signatures of members of the National Assembly to present this motion. And when the motion was tabled on the 27th of September 2024 and subsequently debated on the 8th of October 2024, as has been submitted by my learned colleague, Mr. Gumbo, the motion was supported by 282 members, representing 80% of the whole House. This was not just a majority, but a supermajority. When the motion went to the Senate and the vote was taken, and I'll only rely on one ground number 1, 54 members voted for the motion, 12 against, and 1 abstention. My lords, you have been told that Parliament acted as a lynch mob, but there has never been occasion in the 16 years that this Constitution has existed that Parliament has voted on such numbers. If that were the case, you would have been given instances or other examples where Parliament has acted in this manner. And the reason these numbers were achieved, supermajority in both houses, and you will see that they exceed the BBI numbers. In fact, in the National Assembly, they exceed by almost 60 members of the National Assembly, is because of the weight of the 11 grounds of impeachment. My lords, it is our submission that in our country, there is no country anywhere in the world with a higher threshold of impeaching a president or deputy president in this case than this country. If you go to the United States, for example, in the House of Representatives, which is the lower house, you only require a simple majority to approve the articles of impeachment. It is in the Senate that you thereafter require 2/3. If you go to the Philippines, and here we are comparing presidential systems, you require 1/3 of all the House members to endorse the complaints and 2/3 of the Senate. Nigeria has a system such as ours, and so does Brazil. So it is our submission that the safeguards provided by our Constitution are adequate to ensure that this process is not abused. Our Constitution further requires public participation, and this requirement now sets it apart from those examples that I have given you, where impeachment is handled solely by elected representatives. And as will be submitted by my colleagues, public participation was conducted across all constituencies in Kenya throughout this process. So in fact, my lords, we have no comparative in the world. We have the most progressive and advanced constitution in the world when it comes to impeachment of the president. The argument by the petitioners that either Parliament acted as a lynch mob is again not true. The argument that the Deputy President was elected by the people, whereas is true, the contra-argument is that he was also sponsored by a political party to run for office. He ran for office as Deputy President under the banner of a party called the United Democratic Alliance, UDA. And my lords, under Article 38 and under Article 91, political parties are the foundation of our constitutional democracy. In the National Assembly, at the time the Deputy President was being impeached, the UDA had 144 members of the National Assembly. Out of those, 114 voted to impeach the Deputy President, with 21 voting against. And it is our submission that it is clear that he had lost the confidence of his own political party to continue holding office. Our colleagues have cited numerous authorities from South Africa, and South Africa is a good example of how leaders respect decisions of political parties. President Mbeki in 2008 resigned after he was recalled by his own political party. He was not heard by the party. He was not invited to any hearing. The party just met and said they had lost confidence in him. This decision was submitted to him, and he said that he respects the decision of the party, and he resigned. The same thing happened to President Zuma, who resigned on Valentine's Day of 2018. And the following day, President Ramaphosa was sworn in. The party simply said, "We have lost confidence in you." Closer home here in Zimbabwe, when President Mugabe was removed as leader of ZANU-PF on the 19th of November 2017, again he opted to resign because he was going to face an impeachment vote. Parliament is often considered the highest form of representation in a democracy because it serves as a primary venue where elected members represent the diversity, will, and sovereignty of the people. It is our submission, Your Lordship, that the first petitioner not only lost the confidence of Parliament, but he had lost the confidence of the political party that sponsored him to run for political office. My lords, you have been told a lot about the grounds of impeachment. And in Article 145, the framers of our Constitution and the context of our Constitution has to be read in its plain text. They gave 3 grounds for impeachment, and they said gross violation of a provision of this Constitution, and where there are serious threats of believing that the President has committed a crime, and for gross misconduct. There was very good reason for the drafters to give these 3 reasons, because they were not to subject the president or the deputy president to judicial standards by members of parliament. They were not to subject them to judicial standards. The charges against the deputy president, 11 of them, are not to be subjected to judicial standards. I know my colleagues will give you examples of how other presidents have been impeached. But presidents all over the world have been impeached for far lesser crimes, for far lesser transgressions than you have seen here in our country. Here the impeachment was on serious violations of the Constitution. I'll go to the grounds of the impeachment, my lords. And you are told about subsidiarity. Ground number 6 of the impeachment, where the deputy president was accused of crimes under the National Cohesion and Integration Act. Ground number 7, where he was charged with the economic crimes under the Anti-Corruption and Economic Crimes Act and the Proceeds of Crime and Anti-Money Laundering Act. And ground number 8, where he was charged with contravention of Section 29 of the Leadership and Integrity Act. You have been told that there should have been deference by the National Assembly to the institutions, that is NCIC, EACC, and the DCI, to allow them to investigate those crimes before Parliament could do the duty that they did. That is not true. And we are guided by a decision of this court by a 5-judge bench in petition number 295 of 2018, Philomena Mbete Mwilu versus DPP and others. This was a 5-judge bench, Justice Omondi, Justice Ngugi, Justice Tuyot, Justice Musyoka, and Justice Muita, delivered in 2019. And in this decision, particularly paragraph 379 of that decision, the judges go on to say, and this was a decision which the Deputy Chief Justice had challenged charges that had been preferred upon her by the DPP in the Chief Magistrate's Court. And the judges say that from the analysis, the following principles emerge. First, in the absence of an express statutory or regulatory provision requiring prior approval or sanction from another authority in order to prosecute a judge or judicial officer will face trial directly in the event that he or she is alleged to have committed an offense. However, and this is the second principle, where there is a specific legal framework for dealing with misconduct and or removal of judges, cases involving misconduct with a criminal element committed in the course of official judicial